Morning, guys. How are you?
Morning.
Are you ready for trials? That's what we're doing. Don't know if there are any questions, but
are you going to
that's
have
our plan.
Are you going to have a simultaneous immunity hearing during the trial?
Haven't made that decision yet. The real focus is going to be on getting ready for a jury trial. As you know, I've been counting. We're at 96 days right now, so that only gives us time to really get ready for one hearing, and that's going to be a jury trial where he gets acquitted. So that's my plan.
So could there be a possible plan for a civil immunity action after the trial and just make the trial the focus?
The trial is the focus. We're looking forward to getting an acquittal at trial, and that's really what counts. If we're going all the way through a jury trial, I look forward to a jury verdict. So that's my plan.
Sorry,
what about witness number 8?
Hearing after the trial? What were you saying there? I missed that.
I think Bob said, could there be a possibility of a civil immunity or something like that afterwards?
But what are your options here when it comes to an immunity hearing? Now that you've said you're not doing April, she's cleared her calendar, now she's filling it up. Her calendar is going to be full before June.
Seem to be.
So what are your options?
Well, we could either decide to wrap it into the trial. We can decide not to. Certainly, one main focus that we have is to get him to a jury and get acquitted. A second focus is then to maintain his civil immunity whenever that becomes relevant. And we'll see about that as the time comes up.
What about
really, those are the alternatives, and that's our plan.
What about witness number 8 lying under oath? Witness number 8.
Let me go ahead.
When will you make a decision about rolling the immunity into the trial? When does that need to be made by?
I don't think that there is a deadline when it needs to be made. I think that the judge might expect a motion to be filed. But my plan right now is to just move forward getting ready for trial. And then that's the best way to look at it because we have precious little time to do it, so that's what we're going to focus on.
Witness number 8 lied under oath. What is the significance of that?
Well, let's just wait till we take her deposition. The state did what they were supposed to do. They let us know of a problem with their witness.
We now know it.
We now know it, and we have an opportunity to talk to her. I think within this month sometime.
When did they tell you, and when do you think they found out?
I know that I found out yesterday. Haven't talked about when they found out yet.
Mark, do you think it's potentially damaging to her credibility given the gravity of what an important state witness she could be?
I'll remind you of what I said to you when there was a question about George's credibility with another witness saying something bad about him, or the judge's comment about him sort of standing moot when his wife said something. Credibility is always an issue with any witness. And if it rises to the level where it is evidentiarily significant, then it will come in. And if it doesn't rise to that level, we deal with it. This is the underbelly of getting ready for a trial. You find out about witnesses, you find out what they say. If there's conflict, you talk more about it. That's all.
Your client's wife was charged with perjury for lying under oath. Do you think witness 8 should be charged with perjury?
I don't make those decisions. That's up to the prosecutor. If they have a case that they believe a statement under oath has been made contradictory to another one, they have the right to do that, whether it's wherever it happened, or whatever the prosecutor is. That decision will be made by them. I'm not going to speculate on what they should or shouldn't do.
When would that statement be relevant in your mind to come up so that you could question her credibility? Like what?
A trial is so dynamic, you never know when what becomes relevant. But certainly, if a witness, any witness, this witness or any other, came up with a statement that contradicts other testimony, then we can use that, or the state with my witnesses could use that to impeach, and that's how it comes into evidence.
How important of a witness, I know you haven't deposed her yet, but from what you know at this point, how important of a witness is she to the state, and how much focus will you give her credibility?
Well, my opinion really doesn't matter that much, but since I gave it once before, I'll remind you that what I said was I think witness 8 is a very significant, if not the most significant witness, because her testimony so far has been that she was there or on the phone talking with Trayvon Martin when he passed and before. So yeah, I think it's very, very significant witness. How it pans out in trial, we'll find out.
What are the names of the 14 people whose records you were seeking from FDLE?
I know that at least some of them are protected by court order, so rather than vet through those that are and those that aren't, I haven't even seen them yet, so when I see them, we'll find out.
Can you list for me the names of those who are public?
I really couldn't list right now the 14 that we asked for and decide who wasn't relevant, but I don't know.
Did you
I mean,
today
I know them, I just don't have them memorized.
Did you today get the addresses, or get an order that you will get the addresses of Trayvon's mom, Trayvon's dad, witness 8?
I think the judge ruled the opposite. I thought the judge ruled that, for example, I heard the judge say that mom's address was going to be redacted from the Trayvon Martin biography. So I don't think that she's changed a prior ruling where she ruled that we would not get those addresses until we get them a deposition.
When did you find out about those profiles? And I know FDLE's lawyer said that a lot of this stuff is not relevant, but they're the ones who asked the questions. So what do you know, when did you find out about these profiles? And
we found out 6 or 8 weeks ago, and I'm maybe a little bit off, when we went to FDLE pursuant to the court's order allowing us to. We found out, I think that was the first time we found out about the bios. Don't hold me to that, it might have been earlier. And you know, I appreciate Mr. Margolis' suggestion that he knows what's relevant. I would like to be able to make that decision myself, so that's why we're looking at getting the information. And then the judge, finally, is the one who truly determines what's relevant when we try to get it into court.
To clarify what is being turned over regarding the victim, Trayvon Martin, are you going to get a criminal history of his juvenile record if one exists?
I think the court's ruling was that we get the FCIC criminal history on those witnesses for which they exist with certain redaction. And if you're asking me to interpolate, does that mean that Trayvon Martin has one? I have no idea. Right. But if he does have one, will we get it? I think her ruling said that we would. I just don't know if it exists.
Mark, what exactly did the state tell you about witness number 8? Besides lying about being in the hospital, what else?
That was the only relevant issue. It was a very brief conversation with Mr. Guy that simply said, here's some information. We have a hearing set for tomorrow on records that we now don't believe exist. So let's address that. And I appreciate him letting us know. And then it just needs to be dealt with. So no records, no need for a subpoena, that's all.
They said to you she lied. You extrapolated that from the obvious because there are no medical records, because I know they wouldn't or didn't say that today.
I mean, I didn't record my conversation with Mr. Guy, but very simply he said, you're looking for records because she said she went to the hospital. We now know that she did not go to the hospital. But that's really it.
Mark, you said today that you don't have much time and much money to get the case together. Based on this hearing today, do you feel you got a little more, you bought a little more time, or you've got to work a little harder now with these revelations?
Well, I will tell you that part of the decision not to have the hearing, there's a multitude of reasons. One of the reasons is it looks as though Judge Nelson has given a very firm trial date of June 10th, trying to look at the next 96 days and how we're going to focus our time, even though the presentation or the proof is similar evidence. We just don't have the time to take the time to spend 2 weeks or so getting ready for and putting on an immunity hearing then. So that sort of started the conversation among the team members, and then we sort of worked through it as to what we really need to focus on. That's why we decided to focus on the idea that George wants to have a jury of his peers decide the case. It's going to be, I think, a more accepted result for everyone who has to accept the result that he gets an acquittal at trial, even more so than an immunity hearing being given by a judge. So that's another consideration.
How is his fundraising going, and are you closer to being able to hire experts that you are interested in hiring? And last time we all did this, I think you were saying you were considering whether he would file for indigency. That hasn't happened. Give us an update on that.
My understanding is that some $25,000, maybe $30,000 came in since the update of the defense fund. Most of that has now gone back out to retain some experts and other necessary legal expenses. We are still in dire straits for money. We're going to do what we can do, but you know, everything in this case is very expensive and very focused, from the media coverage to what it takes to put on a good criminal defense. And we're going to do whatever we can do with what we have.
Thanks, Mark.
Thanks, guys.
Thank you, Counselor. Rionda, could you join us, please? That's great.
I'm thrilled to have you here.
Who's doing that? First question. The question of whether she lied under oath and whether it's
let me, if I just make a statement, just to be consistent. I don't want to be a hypocrite. I have previously filed at least 2 motions for gag orders in terms of, and I know you all, the media, are doing their job, and you're doing a great job of it. My job is to try the case in the courtroom. And I don't want to belabor that point, but that's been our position from the get-go. I sat there or stood there to watch Mr. Romero make comments because I was interested to see what he would say about why apparently we're not having now a stand your ground motion. Or we are, I don't know, that's still, I guess, I'm bewildered. So I'm not going to be making any comments about specific witnesses because quite frankly, we need the witness to speak when they tell the truth under oath in a courtroom and let the evidence speak for itself. And so I'm not going to be getting into got you that as to who's important, who's not. Let us decide who's important. Let the public decide who's important and who's not. And I'm sorry, I'm not going to answer it. I'll be glad to listen to whatever questions.
In general, when a witness lies under oath, how
Zimmerman lied, you charged her with perjury. Why aren't you charging witness A with perjury? Explain the law about materiality and official procedures.
Well, the law speaks for itself. You all can look at the law and make your determination.
What's your
in
reaction
general,
to the
when
dates
someone
being
is
waived, Mr. Rionda, on the stand your ground? How does this affect you? I don't know how much detail you can go into, but the fact that those dates are now waived.
You know, since that really isn't germane to the issue, I'll tell you, it saves the public from having to have reservations here for 2 weeks. So in that sense, it's good. I'll be able to be with my family. Mr. Guy will be able to be with his family in Jacksonville.
in general, when a witness lies under oath, how damaging is that? I didn't think you'd answer my question. Thank you.